Hello, I'm Ethan Chase. I'm a New York-based organization development coach. And for purposes of sharing this video today, I need to tell you that I am a business coach focused on helping organizations to grow through initiatives pertaining to their people, creating great workplaces for their employees, creating amazing cultures. So in other words, preparing organizations, businesses to succeed in the 21st century. So having said that, and I've been doing this for 15 years, I want to share a video today that is not something that I typically do. If you've gone to my YouTube channel, you see I have 2 seasons of Chasing the Dream where I talk to leaders about culture. You've seen my other videos, no doubt. I focus the spotlight on organizations that are doing great things like Morningstar and Nucor Steel. I also turn the light onto other organizations that are struggling with their culture and how they treat their employees. But today I felt compelled to shine the light on something else, which was the recent Supreme Court decision on overruling the Chevron Doctrine. And so I know, in speaking to a lot of people over the last few days, that we've lost sight, I think collectively, in terms of the timing of focusing on this most recent presidential debate between Biden and Trump, where I don't think enough people are focusing on truly already the ramifications of the Supreme Court's decision, a power play, actually, to snatch control over regulatory concerns over various industries from the U.S. legislature. So I want to talk today about the Chevron Doctrine from the perspective of how we may start to anticipate the impact that that's going to have on business and industry, and certainly not going to be something that's positive for either employees or people who have to contend with corporate greed and excess and lacking ethics and morality. So let's dive right in. I like this kind of intro from Good Morning Hawaii. So we're going to start here, and then we're going to dive right into what this means.
Supreme Court has also upended a 40-year-old decision that made it easier for the federal government to regulate the environment, public health, workplace safety, and consumer protections. The justices overturned the 1984 decision known as Chevron. Billions of dollars are potentially at stake in challenges that could be spawned by the ruling. The heart of the Chevron decision says federal agencies should be allowed to fill in the details when laws are ambiguous. Opponents of the decision argued it gave power that should be wielded by judges to government experts. And a response this morning to the Chevron deference from Senator Brian Schatz, it says in part, in upending decades of precedent, this extreme court has once again tried to make it more difficult for the federal government to serve and defend the public's interests.
So let's start here. Make no mistake, this is pretty damn clear an effort by the Supreme Court of the United States of America, an incredibly conservative court that is being very proactive in taking away people's liberties. They've been doing it time and time again with women in control of their bodies, with immigrants. They're doing it constantly. This is a power grab. This is the Supreme Court telling our elected officials, we know better than you. Those of you who have served maybe for decades in regulatory agencies, we know better than you how to interpret intentionally vague laws that govern the kind of legal, if not ethical, behavior of companies in many different industries and sectors. So that's kind of right out of the gate. So what does this Supreme Court decision mean? Throwing out the Chevron decision, which has been in good standing since 1984, it literally cuts off federal regulators' abilities at the knee. They kneecap them, meaning they're no longer federal regulators in a position to be the primary control or the primary watchdog of companies in many different industries. So executive branch agencies will likely have more difficulty regulating the environment, public health, workplace safety, and other industries and sectors and concerns under a far-reaching decision that was made by the U.S. Supreme Court. The court's majority, the 6-3 majority ruling on Friday, literally yesterday, overturned this Chevron decision from 1984. It was known as Chevron decision, that the Chevron decision up until Friday, which it was overturned, instructed lower courts to defer to federal agencies when laws that are passed by Congress are not crystal clear. Look, most laws require interpretation. And who would you rather see interpret the behaviors of business and industry from a legal, ethical, moral consideration? Legislators who have spent years in their respective government agencies, or the U.S. Supreme Court that can't even control its own freaking website to prevent leaks in terms of upcoming decisions. So they can't even get their own house in order. And then we're not even going to talk yet about the undue influence that conservative business people like the Koch brothers were the backing behind this initiative to overturn Chevron, and their kind of marionette control over some of these these Supreme Court justices, dare I say, Clarence Thomas, paying for his vacations and expensive trips. So that's what's going on. The court 6-3 ruling on Friday overturned this 1984 Chevron decision. Okay, the 40-year-old decision, as we saw in the video, has been the basis for upholding literally thousands of regulations by dozens of federal agencies. But this Chevron decision, if you're not aware of this, this has been the target. This has been a bullseye for conservatives and business groups for many years who argued that this Chevron decision gave too much power to the executive branch, and somewhat critics of Chevron called the administrative state, or undue influence the federal government exerts on businesses, on industry, to follow the laws in terms of ethical practices, non-monopolistic tendencies, caring about the environment, caring about women's rights, baby formula, Medicare, Medicaid. That's all in play now. That's all in play. The Biden administration has defended the Chevron law, warning that overturning it, which the Supreme Court just did yesterday, this so-called Chevron deference, would be destabilizing and could bring a convulsive shock to the nation's legal system. Chief Justice John Roberts, writing for the majority, said that federal judges must exercise their independent judgment in deciding whether an agency has acted within its statutory authority. How do you feel about that? How do you feel about that? And I understand it's a rhetorical question, but based on the proclivity of this conservative Trump constructed majority Supreme Court to go in and overturn precedent, I don't know, like maybe Roe v. Wade, that's been the law of the land for 50 years. The ruling, the Chevron ruling that the Supreme Court just passed on Friday and goes into effect August 1st, the ruling does not call into question prior cases that relied on the Chevron Doctrine. Roberts wrote, woohoo. Okay, so what is the Chevron decision? And this is really important that we understand this. This is how it was just overturned. There were fishermen that sued the federal government over rules that required the fishermen to pay for independent observers on behalf of the federal government to monitor the catch, the amount of salmon they caught, the size, whether they were breeding, whether they were, all that stuff. These fishermen sued the federal government. But what was really going on? What was really going on? With this case and other cases, the fishermen asked the court to overturn this 40-year-old Chevron doctrine, which stemmed out of, from 1984, a unanimous Supreme Court case involving the energy giant Chevron in a dispute over one of the major legislative successes in the U.S. government in past decades, the Clean Air Act. Okay. But what's going on? The current high court, the current Supreme Court of the United States, with this 6-3 conservative majority, has been increasingly skeptical of the power of federal agencies. Brett Kavanaugh, Clarence Thomas, Samuel Alito, Neil Gorsuch have questioned the Chevron decision in other cases. So this isn't something that just hit us. It's been out there for those who have been following judicial kind of action and activity. Ironically, Gorsuch's mother, former EPA Minister Ann Gorsuch, made the decision that the Supreme Court upheld in 1984. So if you take a look at what's going on behind the scenes, it's incredibly upsetting. So President Biden's administration has issued a host of new regulations on the environment and other priorities, including restrictions on emissions from power plants and vehicle tailpipes, and rules on student loan forgiveness, overtime pay. All of these now, these regulations that the federal government, through its administrative agencies, they were going to monitor and rule on these. That's been taken away now. Goodbye. That goes now to federal courts, to the judicial. So it goes from legislative control and monitoring to the courts. And there's billions of dollars at stake from the gun industry and other businesses like tobacco, agriculture, timber, home building. Those industries were pushing the United States Supreme Court to overturn Chevron. And they did. Lockstep. Business and industry, highly influential businesses and senior executives from business and industry, and the Supreme Court of the United States. I am absolutely freaking livid. In fact, the U.S. Chamber of Commerce filed an amicus, a friend of the court brief last year, on behalf of business groups, arguing that the modern application of Chevron fostered aggrandizement of the executive branch, meaning make them appear to be more powerful or more in control than they should be. Okay. So David Doniger, a lawyer and longtime National Resources Defense Council official who argued the original Chevron case in 1984, said that he feared that a ruling to overturn the Chevron Doctrine could free up judges to be radical activists who could, we call it judicial activism, who could effectively rewrite our laws and block the protections on behalf of the U.S. citizenry that they're intended to provide. But this wasn't about salmon fishers. The net effect would be to weaken the U.S. federal government and its ability to meet the real problems that the world is currently throwing at us. Big things. You may have heard of this thing called COVID, where over 1 million Americans lost their lives. But it's more about fish, as I said. The case was never just about fish, said Meredith Moore of the environmental group Ocean Conservancy. What it was really about is businesses and other powerful interest groups using the herring fishery, I misspoke, it's not salmon, it's herring, to attack. This was driven by an attack driven by a desire from business and industry to attack the foundations of public agencies in our government that serve the American public's interest and conserve our natural resources. Okay. All right. Got it. That should start to set the framework for what we're going to dive into next. So the Supreme Court's decision to overrule the Chevron Doctrine is going to actually have such broad, wide-ranging implications that this domino effect, dropping a pebble in a still pond creates a tidal wave. Be on the lookout. So this is something that I wanted to read. Chevron is overruled, said Chief Justice John Roberts. Courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority. Don't know about you, but I have, I don't know, less than 0% faith in the U.S. Supreme Court or the federal court system, the courts, to exercise their independent judgment whether an agency has acted within its statutory. I want the people who are dedicated career government employees who work in those industries, I want them they have that requisite background, experience, passion for making sure that operators, business enterprises that play in certain industry spaces act within the rules, the law of the land, that they're held accountable. I want to read this to you. The Chevron decision from yesterday, Friday, could impact regulations governing Medicaid and Medicare, payment rates, insurance coverage of mental health. In a post-Chevron world, federal agencies can issue regulations interpreting legislation around these health, mental health, physical health, insurance, senior aging concerns. And yet the courts ultimately get to decide whether the agency's interpretation is lawful. This scares the hell out of me. And I'm really curious. I would love to know as you're watching this, if you're having any thoughts or you just don't agree with this. I really value your feedback. If you can make comments, I'll share them. I'll respond to them. I want to have a lively debate. But I want to read this. Associate Justice Elena Kagan, Sonia Sotomayor, and Ketanji Brown Jackson, the three non-conservative judges who dissented from the opinion, from the majority decision. Listen to this. Some interpretive issues arising in the regulatory context involve scientific or technical subject matter. Agencies have expertise in those areas. The courts don't, said Elena Kagan. I mean, agencies report to a president who in turn answer to the public for his policy calls. Courts have no such accountability and no proper basis for making policy. This is really important. I know I keep saying that, but I want to play a little bit of a video from PBS, and we'll listen a little bit to an interview with an expert in this domain. And then I want to just kind of talk a little bit about it on the back end.
Meanwhile, the Supreme Court has now swept aside longstanding legal precedent in its ruling today, overturning that Chevron doctrine, majorly curtailing the power of federal agencies to interpret the laws they regulate. The decision is expected to have far-reaching implications on everything from the environment to healthcare.
For a closer look at the overturning of the Chevron precedent, we're joined now by Andrew Mergens. He spent 3 decades as an attorney for the Department of Justice, Environment, and Natural Resources Division. He now heads the Emmett Environmental Law and Policy Clinic at Harvard Law School. Thanks so much for being with us.
Thank you, Jeff.
And as Amna mentioned, the Chevron case is obscure, but has a huge impact. It's basically shorthand for a long-standing tradition that says if there's an ambiguous statute, the courts defer to the agencies in their interpretation of how to read that statute, because the thinking has always been that the agencies have the expertise. Today, the Supreme Court said, nope, that's no longer the case. How big a deal is this?
I think in the short term, it's a very, very big deal. I think that we're going to see an enormous number of challenges to government regulations in the environmental area, in food safety, in healthcare administration. There will be many, many challenges. And the lower courts and the Justice Department that defends those regulations are going to be very, very busy in the near term.
Do we know how or if this ruling today will affect cases that were already settled under the Chevron precedent?
It's an excellent question. The Chief Justice in the majority opinion says that those decisions should not be up for review merely because they depended on the Chevron deference or the Chevron doctrines. But Justice Kagan in her dissent says that's a very cold comfort, and I tend to agree. This is a very complicated question. It's sometimes very hard to parse out exactly why courts upheld regulations. And I fear that there will be many, many folks ready to test the limits here and to reopen past regulatory judgments and regimes.
I'm going to put the link to all the resources as I started doing in the below, but the key takeaway is, what is this Pandora's box going to bring into question? There is from my estimation, a massive potential adverse impact from a societal standpoint. And that scares the hell out of me, because what we're saying is, the Supreme Court has said in its ruling of the majority that the courts themselves are better positioned to make interpretive decisions around laws than the regulatory agencies that are constructed to monitor and be watchdogs of those companies who compete in these industries and sectors. This scares the crap out of me. It really does. So a little bit further into the Chevron doctrine overruling. So this was a tool The Chevron Doctrine, going back to 1984, was a tool in the arsenal of legislators to exert a modicum of control or discipline or best faith behavior with business and industry. What do we know? What do we know? What have I said time and time again in all my videos? There's this implicit assumption that as we go from the 20th to 21st century, a shift in focus of corporate mindset from shareholder value to stakeholder value. Well, we're still stuck as we transition. A majority of businesses do business to maximize profit and financial performance to give maximum benefit to shareholders. So in that construct, you're going to operate in such a way as to reduce cost and maximize revenue. And that consideration comes at the risk of ethical behavior often and having a moral compass. And ergo, that's where we rely on regulators in the industries that they have subject matter expertise to interpret laws, which are intentionally vague, to adjust and adapt over time with transforming industries, technologies, consumer preferences, lifestyles. I mean, all that stuff. What this means is that the Supreme Court, their 6 conservative judges have decided in overturning the Chevron Doctrine that the courts themselves are better positioned to be the watchdogs, and they're not. They're just not. So federal rules that impact virtually every aspect of life. This is when I said earlier that this is broad ramifications. The food we eat, the cars we drive, the air we breathe could be at risk after this ruling yesterday, Friday. The court rejected this 40-year-old Chevron Doctrine, effectively reducing the power of the executive branch. For agencies like the Environmental Protection Agency, shifting that power to the courts. Okay. All right. It doesn't, the ruling doesn't call into question prior cases that relied on the Chevron Doctrine. I mentioned that. But Kara Horowitz, an environmental law professor and executive director at the Emmett Institute of Climate Change and the Environment at UCLA School of Law, said the decision takes more tools out of the toolbox of federal regulators. By definition, statutes typically don't clearly define how an agency should tackle new and emerging threats, like climate change, that weren't well understood when the decades-old statutes were written. Interesting. So the decision could set back efforts to reduce air, water pollution, restrict toxic chemicals, or even take on new public health threats like COVID. Environmental and public health advocates have already said, I mean, I've read a lot of these articles and they're not even sure yet, but they're concerned. And yet we're so focused on Biden not being able to complete a sentence standing across from the convicted convict and rapist during the presidential debate. That's what we're all focusing on. This has gone completely under the radar. Vicki Patton, general counsel for the Environmental Defense Fund, has said it undermines overturning the Chevron Doctrine, vital protections for the American people at the behest of powerful polluters. Good riddance to Chevron deference, which put a 2-ton judicial thumb on the scale of government bureaucrats against the little guy. It's a big victory for the rule of law. A conservative activist and lawyer, Carrie Severino, said. This is just, I mean, this is just driven. I mean, it's just driven by conservatives, powerful business brokers like the Koch brothers, exerting influence into the conservative courts that want to overturn precedent and decades of already established case law. New York Representative Gerald Nadler, I'm a New Yorker, so I have to share this. New York Representative Gerald Nadler, the top Democrat on the House Judiciary Committee, said the decision comes at the expense of everyday Americans who depend on the federal agencies to look out for their health and safety, not the bottom lines of giant corporations. Well, that's now gone. What's next? Craig Segal, Vice President of the environmental group Evergreen Action, said the ruling opened the door for large corporations to challenge all sorts of federal rules. The dismantling of the Chevron Doctrine grants every Trump-appointed judge the authority to overrule agency experts' interpretation of the law and substitute their own ideological viewpoint for the informed determination of career public servants, Segal said. The days of federal agencies filling in the legislative blanks are rightly over, said Senate Minority Leader Mitch McConnell. Oh, jackass. Okay, so what does this mean for Title IX? Oh, wait, how could this affect Title IX? Of course it does. I said at the onset of this video that this overturning of the Chevron Doctrine, we're going to see that stone dropped into a still pond, and it's going to reverberate and have titanic impact as we start to kind of see what this actually means. In a decision that may be felt in schools and colleges across the United States, the Supreme Court on Friday overruled a major precedent on when courts should defer to federal agencies' interpretations of the laws that apply to them. So this 6-3 decision, Loper Bright Enterprise versus Raimundo. That's when I say the decision that overturned the Chevron Doctrine. Get to know it. The Loper Bright Enterprise versus Raimundo could have near-term implications on matters such as the U.S. Department of Education's recent final regulation interpreting Title IX to protect transgender students. This overturning of the Chevron Doctrine, which is set to take effect August 1st, has been challenged in multiple lawsuits and has already been blocked from taking effect in 10 states. Okay. According to John Roberts, the Chevron decision was misguided because agencies have no special competence in resolving statutory ambiguities. The courts do, John Roberts, Chief Justice, said, adding that the framers of the U.S. Constitution anticipated that courts would often confront statutory ambiguities and expected that the courts would resolve them by exercising independent legal judgment. This is a Chief Justice of the United States, along with 5 other justices using their majority to put their fists down on the scale of justice that is doing, I believe, irreparable damage to our society. They're destroying our ability to control greedy corporations. They're taking away our rights, and it's happening in broad daylight. And we need to figure out a way to work around this. Lastly, the Supreme Court overturned Chevron Doctrine, what it means for climate change policy. We're really covering the gamut. We're going broad. I'm not going too deep because I don't yet understand fully the impacts. It was a day ago, but we're going to monitor this. But the High Court sweeps away a Goliath of modern law, kind of like, this thing called Roe v. Wade, weakening federal agencies' legal authority as the courts weigh Biden's policies to cut greenhouse gases. So this is a tiny sliver from an environmental perspective. Just as federal regulators move forward with a climate change policy rooted in dozens of complex provisions of law, the Supreme Court on Friday overturned the principle that has guided U.S. regulatory law for the past 40 years. So, you may think this is a rant. I don't believe it is. I think this is a clarion call I'm trying to make for us to start to think about when we look at business and industry, when we look at their motivator of profit versus when it comes at the expense of the public good and the public trust. We have elected officials to stand in who we've elected. We voted into office ostensibly to protect us from them. And this decision is the Supreme Court saying yesterday, we're going to take away that ability of your elected officials and your regulatory agencies who are experts in these things to provide guidance on interpreting laws. We're going to take that away. And we, the court system, the judiciary, that third branch of U.S. government is going to step in. And we think we know better. And they don't. So please, 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 if you like this video, please like it. If you think it's important, share it. If you like the work that I'm doing, this is, again, not something I typically do this kind of video today, but if you like the work that I'm doing on my channel, please be sure to subscribe. It really does help me out supporting these initiatives. So thank you so much for checking in and have a great day.